Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Today we're bringing you a special bonus episode, brought to you in collaboration with the folks over at the Legal Writers Collective. Go on and check them out on our website or at legalwriterscollective.com. Hope you enjoy. The Queen and Plange. Court of Appeal for Ontario. Heard July 3rd, 2019. On appeal from the sentence imposed on March 20th, 2018 by Justice Sean S. Nakatsaru of the Superior Court of Justice. Appeal Justice Bonotto. The Crown appeals the sentence imposed following the respondent's guilty plea to a $41 million fraud. The Crown submits that the sentencing judge erred, 1. in striking down the mandatory minimum, and 2. by imposing a sentence that was demonstrably unfit. The respondent pled guilty to one charge of fraud over $5,000. The charge alleged, quote, that he, the said Kevin Ecow Plange, between August 13, 2013 and July 28, 2014 in the City of Toronto, in the Toronto region, and elsewhere in the Province of Ontario, by deceit, falsehood, or other fraudulent means, unlawfully did defraud or attempt to defraud the Government of Canada of money in an amount greater than $5,000 by preparing and submitting false RC366 e-direct deposit requests, payroll and or corporation income tax forms to the Canada Revenue Agency to change the direct deposit information of corporations, and as a result redirected or attempted to redirect goods and services tax refunds and other payments properly payable to corporations to bank accounts controlled by him, thereby committing an offense contrary to Section 381A of the Criminal Code of Canada as amended." End quote. The guilty plea proceeded on an agreed statement of facts. In the agreed facts, the respondent acknowledged that he had redirected GST funds properly payable by the Canada Revenue Agency to various corporations to bank accounts he controlled. In total, $41,831,073 were directed into his accounts by the CRA. The respondent managed to get only about $15,000 out of the accounts. Because the subject matter of the fraud exceeded $1 million, the respondent was subject to the 2-year mandatory minimum jail sentence provided for by Section 381.1. The respondent argued that the mandatory minimum punishment was unconstitutional as applied to him and unconstitutional as applied in certain reasonable hypotheticals. The trial judge rejected the first submission but accepted the second. He declared the mandatory minimum unconstitutional and Section 380.1.1 of no force in effect. The trial judge went on to impose a sentence of 13 months and 18 days, 18 months reduced for credit for pre-sentence custody and pre-sentence bail conditions, to be followed by 2 years probation. The Crown appealed. The Crown argued that the mandatory minimum did not constitute cruel and unusual punishment. The Crown further argued that regardless of the constitutionality of the mandatory minimum, the sentence imposed on the respondent was manifestly inadequate. At the end of oral argument, the court advised the parties that the decision on the constitutional question would be reserved. However, the court indicated that the sentence imposed was manifestly inadequate. A sentence of 3 years should have been imposed. The court further advised the parties that it was not in the interests of justice to re-incarcerate the respondent at this time and that the court would not do so. Finally, the court advised the parties that written reasons would follow. These are the reasons. Facts. Taxpayers, including corporations, who are entitled to refunds or rebates on various taxes, can arrange to have the funds deposited directly into their bank accounts by the CRA. The user-friendly process established by the CRA requires only that the taxpayer file a Form RC366, directing that the funds be deposited into the specified bank account. This form is available on the CRA website. Between August 2013 and July 2014, the respondent filed 28 fraudulent RC366 forms, purporting to change the direct deposit information for 12 major corporations. He directed that the funds be deposited into his own account at the TD Bank, or accounts at other banks he set up for the purpose of receiving the funds. In completing the RC366 forms, the respondent used information such as corporate addresses and business numbers. He also forged the signatures purporting to confirm the certification of a corporate officer or director authorizing the change in the bank account into which the funds were being deposited. The respondent filed his first group of fraudulent forms in early August 2013. Those forms directed the funds to his personal bank account at the TD Bank. Within a month, several deposits from the CRA, totaling almost $6 million, had been made into his account. More deposits followed in October, totaling over $15 million. Another $15 million was deposited in December. The respondent could not, however, access these funds as the TD Bank froze them. In early 2014, the respondent filed another batch of fraudulent RC-366 forms. With this batch, however, he changed his process. By using different banks and multiple accounts, he sought to circumvent the bank's oversight. More than $5 million was deposited by the CRA. Despite ongoing and persistent efforts to free up funds, both by repeated calls to his banks and by many calls to the CRA seeking information that could facilitate access to the funds, the respondent only managed to get $15,290 out of the accounts. The scam ended in April 2014. The respondent testified at the sentencing hearing. The trial judge also had the benefit of a lengthy and favorable pre-sentence report. The respondent described his year-long effort to fraudulently divert funds from the CRA to his own bank accounts as an impulsive response to learning about a tax loophole. Despite this entirely self-serving and inaccurate description of his conduct, the trial judge accepted that the respondent was remorseful and had taken full responsibility for his actions. In his evidence, the respondent attempted to explain his fraudulent conduct by referencing very large gambling debts he had accumulated. The respondent told the judge that he intended to pay off his gambling debt with the proceeds of his fraud. The trial judge found that the respondent did not commit the offense to pay off his debts, but like most fraudsters, was motivated by greed. Analysis. I begin with a consideration of the mandatory minimum punishment for fraud over $1 million and then turn to the fitness of the sentence. Mandatory minimum punishment. Section 380 sub 1.1 of the Criminal Code provides that a person convicted of fraud exceeding $1 million is subject to a mandatory minimum punishment of 2 years. The respondent submitted before the sentencing judge that this provision violated Section 12 of the Canadian Charter of Rights and Freedoms because it constituted cruel and unusual punishment. Section 12 of the Charter reads, "Everyone has the right not to be subjected to any cruel and unusual treatment or punishment." The sentencing judge followed the two-step analytical approach to Section 12 claims. At the first step, the sentencing judge determined that the mandatory minimum sentence would not be grossly disproportionate for this offender. He then moved to the second stage to consider whether the sentence would be grossly disproportionate for other offenders. Here, he identified 3 reasonable hypotheticals. A mortgage fraud involving a self-employed offender who overstates his income or financial worth to obtain $1 million mortgage. The overstatement is not significant. In the offender's eyes, the financial statement was not dishonest because the self-employment income was based upon an aberrant year when income dipped from regular levels due to some unusual event such as an illness. The sentencing judge found that to sentence this offender who had no prior criminal record to a penitentiary term would shock the conscience of the community. A situation where a young college student impulsively submits one change of a corporation's direct deposit information to the CRA. He does it for pure curiosity to see if it would work, or even out of altruism to uncover a defect in the system. The offender has no idea how much would be redirected to his bank account if it does work. To his surprise, $1 million is deposited. He is shocked, remorseful, and immediately calls the bank to advise that this was a mistake. The sentencing judge found that a 2-year sentence would be grossly disproportionate given the nature of the offense and the minimum moral blameworthiness of the offender. A situation where the spouse of the accused, knowing what the accused was going to do, permitted the use of their joint bank account to receive any direct deposits from the CRA. As a party, the spouse too would be sentenced to a mandatory minimum sentence of 2 years. The sentencing judge concluded that in these reasonable hypotheticals, the moral blameworthiness of the offender is significantly diminished, and, assuming the offender makes full restitution, no actual economic harm is caused. Consequently, it would outrage the standards of decency and shock the conscience of the community to impose a 2-year sentence. Having made this determination, the sentencing judge then determined that the impugned provision breached Section 12 of the Charter and was not saved by Section 1. The appellant submits that the sentencing judge erred by considering these 3 hypotheticals. The first 2 do not amount to fraud, and the third does not establish a reduced moral blameworthiness such that the mandatory minimum would shock the conscience of the community. The offense of fraud requires the Crown to show that an accused has committed a dishonest act by deceit, falsehood, or other fraudulent means, and that a deprivation has been caused by this prohibited act. The deprivation may consist in actual loss or placing a victim's pecuniary interest at risk. The mens rea for fraud requires the specific intent to deceive, lie, or commit some other fraudulent act. The mens rea for fraud excludes from its ambit negligent misrepresentation, misstatement, or improvident business conduct. An act of deceit, made carelessly or as a prank when the person has no knowledge that the property of others would be put at risk, is not fraud. Fraud is a deliberately practiced fraudulent act at which, in the knowledge of the accused, actually put the property of others at risk. The first hypothetical invoked by the sentencing judge involves a self-employed individual who fudges income to correct for an aberrant year so as to qualify for $1 million mortgage. This hypothetical does not amount to fraud and is not reasonable. Fraud involves intentional dishonesty. In constructing the hypothetical, the trial judge assumes the putative offender commits fraud, but goes on to state that the putative offender does not see the financial statement as being dishonest. This shift in the hypothetical removes the example from the ambit of criminal fraud. The accused in this hypothetical intended no dishonesty. The second hypothetical is also problematic. The young college student who submits the same forms as the respondent out of curiosity or altruism has not intended to deceive or put the property of others at risk. This hypothetical lacks the mens rea to establish fraud. It is also, in my view, far-fetched. The hypothetical involving the spouse of an accused, such as the respondent, who allows the accused to utilize their bank account to perpetuate the fraud, is unconvincing. If, as the hypothetical suggests, the spouse has full knowledge of the fraud and agrees to provide a bank account to facilitate the scheme, there is no principled reason why the mandatory minimum should not apply. Party participation is not a reason to lower a sentence from that of the principal. In my view, the judge's use of these hypotheticals to declare the section unconstitutional was in error. Therefore, the mandatory minimum punishment, on this basis, cannot be struck down and the appeal must be allowed. The question then becomes whether this court should create a hypothetical of its own in order to declare the section unconstitutional. This is where I part company with my colleague Appeal Justice Doherty. He agrees that the hypotheticals used by the sentencing judge do not lead to a declaration of unconstitutionality. However, he would construct a different hypothetical. I would not. I do not agree that it is this court's function in this case to construct the hypothetical in order to declare the mandatory minimum unconstitutional. I say this for 3 related reasons. 1, the onus is on the party challenging the validity of the legislation to establish the hypothetical. 2, the parties, particularly the Crown, should have the opportunity to fully address the hypothetical. And 3, there is no prejudice because the issue remains to be determined on a proper record in the future. Onus. The onus is on the party challenging the validity of a legislative provision to establish a reasonable hypothetical. This was confirmed by the Supreme Court of Canada in the Queen and Goltz. Quote, on the second aspect of the Section 12 analysis, the onus is to demonstrate a reasonable hypothetical circumstance in which enforcement of the statute would violate Section 12 for imposing excessive or grossly disproportionate punishment remains with the party challenging the provision's validity. In the instant appeal, that onus was not discharged. Consequently, the challenge based on the second and hypothetical limb of the Section 12 inquiry must also fail. End quote. On this basis, the challenge with respect to the constitutionality of Section 380 sub 1.1 must also fail. By placing the onus on the party seeking to challenge a mandatory minimum provision, the law ensures that the Crown and the court have an opportunity to fully examine the reasonableness of the hypothetical. I turn to my second reason, the importance of submissions. Submissions required. When a legislative provision is challenged on the basis of its effect on a reasonable hypothetical offender, the parties, in particular the Attorney General, should have an opportunity to fully respond. As my colleague says, the hypothetical he relies on was put to the parties in oral submissions. However, the brief discussion did not relate to the reasonableness of the hypothetical, but rather to the fact that the conduct would be captured by the mandatory minimum. The facts underlying the hypothetical were not vetted. This is significant since I, for one, am not convinced that the hypothetical discloses opportunistic or spontaneous conduct on the part of the hypothetical offender. Nor do I agree that it lacked sophistication. Quite the contrary. I do not accept, without submissions, that one could come across direct deposit instructions on the CRA website that could be used for a diversion of funds belonging to someone else. The fraud would involve multiple, rather sophisticated and dishonest steps. A suitable corporation would have to be identified, the business number fraudulently obtained. A corporate search would be necessary to determine the proper name of the corporation and the names of the officers to be forged. The form itself would have to be completed and filed. I raise these matters not to conclude that the hypothetical is not reasonable, but rather to demonstrate why submissions would be necessary in order for this court to conclude that a 2-year prison sentence for this hypothetical offender would be grossly disproportionate. I agree with my colleague that to test the law, NER requires the court to look at the offender and others. The issue here is not whether the court can consider reasonable hypotheticals. Clearly it can. The issue is whether, on the facts of this case, this court should construct a hypothetical not considered by the court below and not fully argued in order to declare a legislative provision unconstitutional. No impediment to a future consideration. Finally, I note that the issue of whether Section 381.1 breaches Section 12 of the Charter may be considered in a different context. As the Supreme Court said in NER, quote, a court's conclusion based on its review of the provision's reasonably foreseeable applications does not foreclose consideration in future different reasonable applications, end quote. Consequently, I would allow the appeal of the constitutional ruling and set aside the trial judge's declaration that Section 380 sub 1.1 of the Criminal Code is of no force and effect. Fitness of sentence. The sentence imposed by the trial judge was demonstrably unfit when compared to other large-scale frauds. In the Queen and Koval, Justice Watt, as he then was, found that large-scale commercial frauds attract sentences of 5 to 8 years where large sums of money are put at risk. In the Queen and Watts, the court set a sentencing range of 4 to 8 years in a case involving a large-scale fraud where $10 million was put at risk and the accused obtained $150,000 from the fraud. The fraudulent scheme involved the filing of false tax documents. Other large-scale frauds implicating loss or risk of approximately $2 to $40 million have attracted sentences of 3.5 to 8 years. More recently, this court confirmed that in cases of large-scale fraud, the range is generally 3 to 5 years. The sentencing judge also erred by characterizing the fraud in a manner that was not supported by the evidence and mitigating the respondent's sentence on that basis. He reasoned that because the respondent's fraudulent scheme was unique and unsophisticated, this mitigated in favor of a lower sentence being imposed. The unique aspects of the fraud, according to the sentencing judge, are that it was accomplished by simply downloading a form available from the internet and filing it with the Canada Revenue Agency. This characterization is incomplete and understates the sustained effort made by the respondent to execute the fraud. The form itself reveals that there was significant research involved in completing it. It ignores the multiple attempts he made to access the money in the attempt to reconfigure his scheme to avoid detection. The sentencing judge understated the moral blameworthiness of the respondent. While the sentencing judge noted the importance of general and specific deterrence, the substance of his approach betrays the reference to deterrence. Instead of focusing on the efforts made by the respondent to advance the fraud, he focused on the lack of sophistication and the inevitable detection of the fraud. For these reasons, a sentence of 18 months was demonstrably unfit. I conclude that a fit sentence is 3 years. The respondent has served the sentence previously imposed, so we turn to the issue of re-incarceration. This court has stated that when a fit sentence is determined to be higher than that already served, denunciation and general deterrence may be achieved without re-incarceration. The respondent's rehabilitation demonstrates that this case does not require re-incarceration to uphold the sentencing principles. For this reason, as stated at the outset of these reasons, the court advised the parties that it would stay the remainder of the sentence. I would allow the appeal, impose a sentence of 3 years with the proviso that it is not in the interests of justice to re-incarcerate the respondent at this time, and I would stay the remainder of the sentence. Appeal Justice Bonotto, Appeal Justice McPherson concurring.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.